Sure.
Mr. Eigenman?
Good morning, Your Honors. My name is Joel Eigenman. I represent the appellant, Zoel Sylvester. I'm a bit surprised to be here this morning. It has been a matter of wonder to me that the Attorney General's office should seek to defend a statute at once so plainly unconstitutional, of such minimal fiscal impact on the Commonwealth, and to do so when it deprives disabled veterans of a very modest benefit at a time when our soldiers are again fighting and dying overseas. But my, I suppose, consternation is of no particular moment. The statute, which imposes a 5-year residence requirement on the receipt of a tax abatement under Section 5 of Chapter 59 for disabled veterans, is plainly bad under whatever test, whatever constitutional test is applied to it.
Would you agree, Mr. Eigenman, that absence the SENS, and I hope I'm correct, the SENS decision of the United States Supreme Court, your client would have no case?
No, I don't agree with that at all.
Okay.
First of all, I think that the law here fails a rational relation test.
Well, what about the Lee? But what about the Lee case?
Well, the Lee case, first of all, was decided at a time when the standard was different, but leaving it simply to the standard, the distinction of the Lee case is quite plain. The Lee case has a statute which requires ownership as well as residence for a 10-year period before the elderly can receive a tax abatement based on their age. This statute says nothing about home ownership, merely residence.
But again, I don't want to get into a semantics argument with you, but Lee is distinguishable on the facts, but with respect to the test it implies, you know, that was decided after Shapiro and the other United States Supreme Court cases. So but for what you claim is a change in the law in SENS, your client would have, let me say, a reduced likelihood of success.
Well, first of all, SENS is a repetition of language in Soto Lopez of Justice Brennan writing for plurality. So it isn't only SENS.
Right.
Justice, in 1986, Justice Brennan wrote for the plurality, the analysis in all of these cases, and he's talking about virtually all of the residence term of residence cases previously. The analysis in all of these cases, however, is informed by the same guiding principle. The right to migrate protects residents of a state from being disadvantaged or from being treated differently simply because of the timing of their migration from other similarly situated residents.
But couldn't we interpret that language as applying to something like welfare benefits or necessities of life and not to a de minimis type or a less important statute of this nature?
No, I don't think you can possibly read it that way.
Well, that's the Attorney General's position.
He's making the point that we no longer require, as perhaps the language in Shapiro would suggest, that it be a deprivation of some substantial interest. And finally, when you get to SENS, the language there is even clearer.
Well, SENS was a welfare case. Soto Lopez was what kind of case?
Soto Lopez was the
a voting case or something?
No, it was a veteran's preference in civil service. But again, when the Supreme Court of the United States says, as it has on at least 2 occasions, explicitly, that the degree of burden on the right to travel is immaterial, that it is unconstitutional, or subject, I should say, to strict scrutiny no matter how light. It doesn't have to show that it truly deters it and so on. The language of Justice Stevens in Science, as I say, is not limited at all.
Well, it's surely broad language. I don't disagree with you on that. We're just trying to figure out, are there any limits to this, or are all residency requirements all now unconstitutional?
Not all unconstitutional, all subject to strict scrutiny.
Strict scrutiny, I got you.
Have any other federal or state courts applied science to require heightened scrutiny of every durational residency requirement?
I'm not aware of such a case, but again, I don't see why, unless there were numerous contrary precedents, and in this circuit, why on earth it would be necessary to disbelieve such clear language of the United States Supreme Court.
Well, the language is clear, but then they sort of carve out divorce. Oh, yeah, that's something else. So residency requirements for divorce are okay. They don't overrule Sosna versus Iowa. They just sort of, well, that's all right. They don't reverse those residency requirements relating to tuition, in-state tuition at state universities. My daughter shows up and says, I'm a resident of Colorado, and therefore I'd like in-state tuition. They'd say, thank you very much. You haven't really been a resident here long enough. You're not going to get it. But the court sort of says, well, that's different.
In that, Your Honor, they specifically say that the state does have a legitimate interest. And
compelling interest, strict scrutiny, compelling interest?
A compelling interest presumptively in limiting a benefit to people with a true connection to the state. That is to say, a benefit like public education, subsidized public education. And I don't know that in that little note they say that quite so fully, but that's certainly the implication. They do speak of the legitimate state interest. I don't remember off the top of my head whether they say it's compelling.
They certainly don't distinguish them very well. They just sort of put them aside as we're not overruling these things, but that's not really at stake here. And that's why I'm asking exactly how broad should we be looking at that very broad language?
Well, we also have the New Mexico case, Bernalillo, which is extremely close in fact to this one. That indeed is a residency requirement for a state tax abatement for veterans. Now, I don't see, as I say, that this court can escape applying strict scrutiny. But again, let's go back to plain old rational relation. The only rationale that's given, that's been suggested by the Attorney General's office, is that, well, even though they may not have been paying directly real estate taxes, they've probably been paying rent, and therefore indirectly they've been paying the heightened real estate taxes. Well, I believe that proves far too much, that reasoning extended could easily, since there's no longer any nexus between any particular, between a tax abatement and a direct involvement with the taxes. First of all, there's nothing in the record to suggest that rents in Massachusetts have been going up faster than in other states, or faster, or as fast as real estate taxes. In fact, there's, and I don't pretend to know this, but there certainly has been anecdotal evidence in the last several years that rents have been falling, whereas the costs of home ownership have been going up. And there's nothing in the record to support that. But one might as well say that because residents in Massachusetts have been paying increasing turnpike tolls or gasoline taxes or food costs, that a discrimination in favor of longtime residents for any benefit that the state gives out is therefore legitimatized, is therefore sustainable. Do we know how many veterans who were not homeowners but suddenly became homeowners had previously paid rent, or how many of them had lived with relatives?
But that doesn't have to be perfect. I mean, this is a rational basis test. That doesn't have to be demonstrated.
Again, the rational basis test, which is extremely broad, I admit, I believe it has to have some grounding, has to touch the earth someplace. It has to have some connection with something that the legislature might have intended, even if we don't know that it did or know that it didn't. And here, as I say, if this disconnection is permitted, then absolutely any discrimination can be justified rationally because somebody in Massachusetts may have suffered from smog or cold weather or who knows what that people from other states presumptively didn't. And therefore we can prefer our own. I think we do have to look back on the background of all of these cases. I think we have to look at Campbell and at Strong versus Colatos and Judge Wysansky's statement, repeated all across the country in many of these cases, that a state is not allowed simply to prefer its own people. And that, frankly, is what's going on here. There's no rational intent to distinguish on any cost basis. It's pure Homerism. This was changed in 1954 is when this was put in. Who knows what was going on at this point in 1954 in terms of rising tax rates?
Well, we can look at the current rationale for not repealing it. I mean, we can look at it in lots of different ways. I agree with you.
That.
Let me. So what you're suggesting, and I know you clearly suggested in your brief, is that Lee was decided wrongly. Lee would not withstand the Sands test at this point.
That's right.
So that tax benefit for elderly folks who've owned their homes more than 10 years would be equally vulnerable to this argument.
Yes. But even if we didn't have Sands, this case is not nearly as strong as Lee. And I don't know if I need to touch on the second rational basis advanced, which is that it gives an opportunity to predict wild fluctuations in the numbers of disabled veterans claiming this benefit. It's hard to imagine how that might arise. I suppose a sudden persecution of disabled veterans in Rhode Island leading to a mass in-migration of refugees. I mean, but to look at it, again, there's nothing in the record suggesting that the decennial census gives us any way of knowing who is a disabled veteran, who is a veteran, who owns a house, what their names are. This is pure fantasy. It just doesn't. And simply, again, the idea of prediction, if on this record prediction of the tax burden carries the day, again, that's infinitely extendable. Absolutely anything could be justified that way. Let me, in the minute and a half I have left, let me try to touch on two other things. One is my suggestion in both below, in the court below and here, that the Massachusetts Declaration of Rights provides an independent basis for knocking out this statute. That's not just a throw-in. That's not a joke. I believe the language of that provision is effectively an equal protection clause. Granted, it was probably intended and directed at patents of nobility and that sort of thing, but that's not the language that's used. It says no classification that gives any class of people a benefit for any reason other than public service is permissible. It's very much like the 14th Amendment in this respect as well. The 14th Amendment, we all know, was primarily directed against racial discrimination, but that wasn't limited in its language to that, and it has been much more broadly
Mr.
applied.
Eichmann, forgive me, was there a state constitutional claim in Lee? Can you recall?
Lee? I don't remember.
I think specifically not. In fact, I think there's a
don't
footnote.
recall.
Thank you.
But,
raised the same claim in a veterans preference case 35 years ago, Hutchinson, but I don't think it was ever necessarily decided or necessary to the decision in that case. Finally, now the time is up, I assume that the material in the back of the Attorney General's brief about what to do on remand with other issues which have never yet been reached is not part of this appeal or part of this case, class action status and that sort of thing. Thank you.
Thank you, Mr. Eigenman. Mr. Barnico?
Good morning. May it please the Court, my name is Thomas Barnico, Assistant Attorney General, and I represent the Commissioner of Revenue in this case.
Could you give us, please, your best argument as to why our Lee case survives Sands?
Certainly, Your Honor. First of all, science does not expressly overrule any prior case which handled the question of a modest benefit granted by the state. By that I mean a benefit that does not involve the necessity of life or one that does not involve a fundamental right such as voting. Second, it does not overrule, excuse me.
Is there case law subsequent to the 1999 decision that draws those limitations?
Yes, Your Honor.
Other than law review articles and...
Yes, Your Honor. Page 28 of our brief collects what we could find, court decisions.
I saw that. Perhaps I should have amended that to say have there been any intermediate federal courts or courts of last resort?
No, not if it's not in our brief.
Okay.
Federal courts are generally on the sidelines here as to anything that would involve a tax exemption like this because of the Federal Tax Injunction Act tends to channel.
Let me ask you this. If you are correct that it's a necessity of life, something that's been recognized as, fundamental importance, do we even have to decide whether or not it's perfectly acceptable for the Commonwealth of Massachusetts, I'm talking under the federal Constitution, to simply say we are going to give a preference to our citizens?
No, not strictly a
I mean, our
favor-
residents, forgive me.
Longer-term residents.
Correct.
Right. No. And so Massachusetts laws have fallen in the past for failure to identify a legitimate basis beyond that. One of the federal cases that...
Sure. So you would say that we can essentially, and that's Justice Cowan, the import of Justice Cowan's questions, that Lee and Sens go hand in hand. I mean, they're entirely consistent.
They can be harmonized by reading signs to maintain a distinction among benefits and rights. That
Okay,
is.
do you have other reasons? You gave your first reasons why
Yes.
why Lee survives. What other reasons would you
Yes,
give?
the second reason also goes to what signs does not say. It doesn't overrule. In fact, it doesn't even cite Madden versus Kentucky, a United States Supreme Court case under the Privileges or Immunities Clause of the 14th Amendment, which strongly rejected a privileges or immunities claim against a tax question, tax distinction. That was not a right to travel case, but it's an important step for the court to analyze as it reviews the history of the 14th Amendment Privileges or Immunities Clause, starting with its adoption in the mid-19th century, moving on to the importance of the slaughterhouse cases, to the construction of that clause, and of course now ending at the Sines case in 1999. So without even mentioning Madden, we find it hard to believe that Sines could state such a categorical rule which would now invigorate the clause to such an extent as to require strict scrutiny of every tax distinction involving between longer-term residents and other residents. The other points in favor of our reading would be, just as I mentioned earlier, although the case law after Sines isn't fully developed, certainly, plaintiff couldn't say that the courts are uniform in
No, no,
now
no.
concluding that it's a categorical rule that all durational residency requirements are subject to strict scrutiny. I'd add next that commentators haven't read it that way either. In fact, one of the leading treatises cited in our brief poses as a hypothetical after signs exactly this case. That is, what is the fate of a property tax?
She's a very thoughtful dean.
Well, it just so happens that that hypothetical, which brings us here to not so hypothetical.
Well, I was hoping that perhaps some other court might have made inquiry of that question.
Not yet, Your Honor. But there are two additional reasons, I think more substantive as to the actual language of signs that I'd like to mention. And that is, as Justice Cordy was suggesting, the opinion does include some canvassing of prior decisions, and so it's a dealing in part with this problem of a range of benefits and rights that can be affected by durational residency requirements. And so it puts to the side questions like tuition and residency requirements for a break for tuition, and it puts to the side the question of the divorce decree in SOSNA. And the reason why it does so is, even under signs, it remains important to analyze whether the need for the benefit turns on the length of time in the state. And that's really the crux here. For example, in a voting case or a welfare case or a medical aid case, those previously subject to strict scrutiny, in each of those cases, the plaintiff's need for the benefit was immediate.
Well, all you're saying, in other words, is that it's a necessity of life.
Well,
I mean,
he's including voting in
or
that.
citizenship, that is very important.
Yes, but science takes it one step further that's important for us here today, because here, of course, our defense for the statute is that the need for the benefit is directly related to the amount of time you spend in a jurisdiction which can be rationally, held
Mr.
to
Barnico,
be
that sounds, at first blush, that sounds like a perfectly rational, if I may say so, distinction. On the other hand, where Congress has attempted to say, no, you can get the benefits that you had in the state of prior residence. So when you get down to the real necessities of life, I mean, that's a pretty tough line to draw.
Oh, we don't quarrel with the outcome in signs. I think it was preordained by Shapiro. And just as we didn't quarrel with that line of cases in Lee, we simply distinguished it by the nature of the benefit. Signs added, I think, some useful language that suggests that you look at a benefit to see if it's connected at all to the length of time that the person is within the state. And here, of course, the defense is that
why, if you're using that test, which may be a perfectly appropriate test, would that apply to divorces, for example?
Divorces would fall on the Lee and our side of the line because, as the court said in SOSNA, you'll ultimately get everything you want. You'll get the adjudication of your decree.
And it's fine if one obtains it ultimately.
Yes.
You are not deprived of
Yes.
something along the line.
Yes, and that's the language in SOSNA that's cited in Justice Cordy's reference to signs. And so SOSNA falls on our side of the line, just as Lee. And, of course, all of these are reasons why we think the Lee analysis survives signs, because it deals with that other kind of case in which the benefit is not involving necessity of life. It does not involve a fundamental right such as voting in the Dunn case. Finally, I guess the final reason is, also mentioned in our brief, is the incongruity we see as arising if you adopt the categorical rule that all durational residency requirements are subject to strict scrutiny. If that's the case, it seems that the newly arrived, with the benefit of the strict scrutiny protection, would stand in a better position than longtime residents who might be discriminated against according to some other category.
Explain that. I saw that in your brief. I had a big question mark. I really want that explained. Give me an example.
Well, if somebody, instead of in Lee, the elderly were preferred, the elderly were disadvantaged, or the infirm, instead of, that is simply the state-geared level of benefits according to one's health instead of one's infirmity, or one's youth instead of one's age. We know from general equal protection law that these are not suspect categories. These people would still have to attack that distinction, but the state could fend off the claim on a rational basis defense, or perhaps an intermediate standard of review for something like gender. So it would seem that these newly arrived acquire protection, even over something like a modest tax benefit, that wouldn't be available to long-standing residents who don't happen to be in a suspect class. Now, the answer to that may be, yes, but privileges or immunities, as read in signs, is so important a right that we will elevate these newly arrived to a place of protection greater than longer-term residents. And maybe that's explainable, and maybe that's where the court ultimately will go with signs. But I think that's a curious result, again, outside circumstances like fundamental rights or necessities of life. These newly arrived, of course, were elevated to that protection of the strict scrutiny in a case like Shapiro or Maricopa County, necessities of life.
One could view, Mr. Barnico, could one not, the voting case not so much as a fundamental right, but the fact that one has to be able to exercise a vote someplace, and typically that's residency. So it's not that the right is fundamental. I mean, one could almost square it with the welfare benefits or the emergency hospital benefits. You have to be able to exercise it 365 days of the year if you happen to be in a jurisdiction where an election is taking place. And so what you're really doing is saying to that person, for 1 year or 5 years or however many the residential, you don't have a vote. You don't have access to basic care. You don't have access to a hospital, whatever it is. Correct?
I think Your Honor's point is very consistent with the prior case law's use of the word penalty. I think, given the impact.
I mean, voting happens to be critical to our democracy, so it's an odd one, but...
Well, I think it was properly characterized under the old case law as a penalty for both of your reasons.
What's happening?
And of course,
how about public library cards, if we're going to look to Professor Sullivan while we're about this?
Well, I think that's what plaintiff has to deal with, and that's what Sullivan and Gunther mentioned, is a range of modest governmental benefits that ought to be subject to a rational basis test rather than the strict scrutiny that's previously applied.
Well, we might say that access to books is pretty fundamental.
Well, that may be the next case, but...
maybe in some other states.
And that's an example cited in their treatise, not necessarily our choice, but...
Well, surely the state retains the right to ensure that the residency is bona fide.
Yes.
I mean, so to the extent that the whole focus is ensuring that the residency is a bona fide residency, there still is ability, unclear exactly how far that goes after Sands, but still the ability to require a bona fide residency.
Yes.
But it seems to me your emphasis on the modesty of this particular benefit, I'm not sure that's helpful in my mind. What if the benefit had been a complete property tax exemption? That's a lot of money. That's not modest at all. That can make a huge difference in whether one can pay one's bills or not.
We were using that word to distinguish it from a necessity of life.
All right. But it could be, but how would you distinguish it analytically if this were a larger tax exemption as opposed to
You would have
a
a fight internally, I assume.
You
would have a fight within the Commonwealth, correct?
Over the policy question,
Or whether you give
this
them-
were a complete property tax exemption, so there could be $5,000, $6,000, $7,000 at stake, and it could make a huge difference in whether one could live here or not. But it was still a real estate property tax exemption based on the same qualifications.
I think its modesty has to go to its relation to the necessities of life, not even it could be certainly true. It could be very important for an individual. It could be hypothesized to be a bigger exemption, just as Your Honor's mentioning. But analytically, I think there was clearly those cases, Maricopa County, Shapiro, even Signs, are referring, I think one of the cases refers to subsistence. The plight of the people applying for the benefit was clearly on the minds of the court in those cases. And we think that's a distinction that the court drew well and fully in Lee and ought to be maintained even after the Signs case.
Thank you.
Are you conceding that if strict scrutiny applies, that the statute will fail?
We did not, Your Honor. Our brief says that even in that event, the bases for the law we describe are compelling, but we did not cite a case on that.
Thank you. Mr. LeBlanc?
May I add a factual
You may not. Thank you, Mr. Eigenman.
We're not done yet.
Mr. LeBlanc? Mr. Eigenman, we're not quite finished.
Good morning, Your Honors. May it please the Court. My name is Brian LeBlanc from Murphy, Hesse, Toomey, and Lehane, representing the town of Danvers. Our interest in this case is very limited, so to speak, as we apply the law of the Commonwealth, and I don't want to take up too much of the Court's time in expounding on the wonderful exegesis that my brother counsel has already offered in support of the law. The town does take the position that even under Signs, the Lee case survives, that no fundamental interest is implicated here, that the Privileges and Immunities Clause is not implicated here, that the right to travel is not unduly burdened here, and that there is a rational relationship between this modest tax abatement and the Commonwealth's interest and also the town's interest in calculating how many residents would be entitled to this particular tax exemption in any particular year. My brother counsel Eigerman has raised a question about the legislature's original intent in 1954. I was not alive in 1954, and many people were not. But one of the possible reasons the legislature could have come up with was not knowing when a particular war might start. We might have a whole new class of veterans moving in after a brand new war, and that certainly is true today as it was then. The cities and towns of the Commonwealth are out a certain amount of money as a result of these exemptions. They're entitled to know how much of that money is to be reimbursed, and the Commonwealth, too, would be entitled to know how much money.
Well, you understand that Mr. Eigenman's point is, from a practical point of view, from a town planning point of view, that that's just pie-in-the-sky reasoning, because there's no way for you to know in, for example, a town of Danvers, how many residential veterans, not Vietnam veterans, residential veterans are going to be moving into the town of Danvers from neighboring towns, the western part of the state, the north and southern part of the state, as opposed to from Rhode Island, New Hampshire, Connecticut, New York.
It's more from the Commonwealth's perspective, Your Honor.
Well, he would make the same argument with respect to that, but that's for the Commonwealth to make.
Yes.
Thank you, Mr. LeBlanc.
Do you have any other questions? Thank you.